Welcome back to the Law and Crime Network. I mentioned we were done with the Charles Merritt case out of California, but what's beautiful about covering these things live, you never know what's going to happen. And so at the end of any given court day, the judge will admonish, it's called, the jury members. You know, don't talk to anybody, don't read anything. Sometimes that admonishment can be different, modified, depending on what happens that day. Today was very different. We have a special admonishment from the judge to the jury in the Charles Merritt case.
We'll go ahead and take our recess. A couple of things, but number one, we're not going to be coming back at 1:30. We're going to be off this afternoon. So we'll be back tomorrow morning at 9:30. I know it kind of sounds like a rote message every time we take a break, where I tell you do not form or express any opinions, do not discuss the case, do not discuss the case among yourselves or with anyone else. And that includes, again, not discussing about the case, witnesses, testimony, exhibits, or parties. It's really important to heed that. Someone might be asking, oh, you're a jury, what kind of a case? Oh, it's a murder case. It's about the one where the bodies were buried out in the desert. Well, there's a lot of people here following this. Someone hears that, they say, oh, the juror was talking about the case, and that creates problems. So it's really, really important that you not say anything. If someone says, oh, you're a juror, what case are you on? Just can't talk about it. And that hopefully will alleviate any problems. And with that, we'll see everyone back at 9:30 tomorrow morning.
So the judge is burying the lead there at the end of it, saying, oh, yeah, by the way, people have been talking. Joining me here in the studio is Aaron Keller. What exactly is going on out there in San Bernardino?
Okay, so there's obviously a story behind the story here. The information I have suggests that a trial watcher, someone who was there in the gallery watching the proceedings, was outside the courthouse on the first day of opening statements. And apparently this person heard a juror, or a person he suspected to be a juror, someone wearing a juror badge, okay, walking out of the courthouse and speaking with another person and telling that person, I'm here for a trial that just started today. It's all about a guy down in San Diego who went to the home of a family that he knew and killed them all with a hammer. Then he dumped them all in the desert. And that's how this trial watcher is said to have heard this exchange. Apparently the other person felt uncomfortable and changed the subject. But look, the question is that enough to get that juror kicked off the jury? Apparently this trial watcher mulled over this for a few days, finally went to the judge by handing a note in through the court apparatus. The note got to the judge. The judge called the trial watcher in. Well, no one else was present in the courtroom. Presumably they had a conversation. I don't know much about what happened from there, and then that admonishment. So I heard this information a day or two ago as this person was mulling this over, and this is how it ended. So again, the question is that statement enough of an affirmative statement of opinion to get the juror booted off the case? Apparently not, at least at this point. We don't know if the court's continuing to investigate. We don't know if attorneys are briefing case law on it overnight. Maybe, maybe not. But that's apparently what led to that extended admonishment.
Yes, you hear that sound? That's defense attorneys rifling through various cases to figure out if there is enough to suggest that juror should be excused. Remember, there are, what, 6 alternates on this jury?
Yes.
So it's early on. You don't want to start losing people this early. But there is a provision for that, and maybe if the court can be convinced that this juror was, already thinking one way or the other in terms of guilt or not guilty, then maybe it's just better to start clean and use one of those 6 alternate jurors.
And certainly that's a decision that's going to weigh on the judge because, look, I mean, the judge doesn't want people out there talking about the case. But here's the thing. I mean, this is basically a recitation of the facts. It's said in such a way that is not the way a journalist would say it. There's no alleged, there's no accused, there's no charge, there's nothing to indicate that these are just allegations. It was said in a rather sloppy way to suggest that it was a foregone fact that the defendant is indeed the one that did it. But again, we're playing telephone game here. This is what I'm hearing from sources, you know, and certainly we've seen judges turn around and say, hey, look, I'll warn people more sternly. Maybe the judge is going to speak with the individual juror once that person is identified. You know, we don't know all of the apparatus going on behind the scenes here. We can take educated guesses, certainly you and I. But again, the key question here is that enough of an affirmative statement to get the person kicked off the jury on its face? And on top of that, one of the things that I heard that was really concerning to this trial watcher was the tone. That apparently the person was using a tone that was rather indicative of either one of two things, either disgust or guilt. And the tone, the nonverbal communication, was more concerning than the actual words uttered. And at least that's the version of it that I heard. So, you know, a lot going on behind the scenes here, certainly, and we'll wait and see how the judge is going to deal with this, if the judge indeed thinks anything further needs to be done.
Let's bring Andrew in on this. Andrew Cherkasy, tell us, have you gone through this kind of scenario before? Have you had to deal with this kind of gray area in terms of juror misconduct or alleged misconduct?
Well, it's not necessarily the fact that the juror was what his opinion is. It's the fact that he's not following the basic instruction of the judge. That's a problem. It may not be enough to get him kicked off because it's understandable, but it's certainly concerning.
Yeah, it seems to me when you have a case of this magnitude, these jurors had to be qualified to hang around for a long time. You know, it isn't like you're doing a one-week drunk driving case, which is important in and of itself, but it's not a commitment like this is for these jurors. I mean, this is a life-changing commitment.
This is a potentially a half a year commitment. Yes. That's a long time.
Of course, and the way things have been kind of plodding along, who knows? Mm-hmm. So my point is the judge less likely to boot somebody under these circumstances?
Well, one would think that the judge might be more likely to boot under these circumstances because the last thing any judge wants, and this is universal, look, the last thing any judge wants is to be overturned on some kind of an appeal. So look, the bottom line is presumably the defense knows about this. Presumably it could turn into an issue on the record. And I wonder if some of what we heard on the tail end there from the judge saying, well, you know, people are watching this case and the last thing we want is for people to basically have this discussion you and I are having right now. But, you know, I mean, again, I'll shine light on it based on what I'm hearing from people there locally in the courtroom and conversations that I've had over the last couple of days, that this is what the concern is. And, you know, again, the last thing the judge would want is to have to do a 6-month trial all over again because of this issue. So, again, we would presume, we can guess that if the judge didn't pore over case law before addressing this, that's maybe what's going on as we speak.
I would think so. Real quickly, Andrew, what do you think? Knowing what you know, do you bring some sort of motion? Do you request this juror be excused tomorrow morning before court?
Oh, the defense has to make the motion. The statement he made doesn't seem to be particularly consistent with the defense's interest, and it creates an issue on the record. You always want to create as many issues as you can in case things go south.
Very good. Andrew, thank you so much for joining me today. Very insightful. Good to have the defense counsel position on this case. Andrew Cherkasy will be back, I'm sure, in the next few days, weeks, as this thing unfolds. He's becoming an expert on it. I appreciate the visit the last couple of hours. Happy to be here with you. We've got so much going on tomorrow with an update on Jamie Klaus. We have an update, of course, on the merit case as it will continue back in action tomorrow. And coming up in just a few moments, Aaron will be right back, and the daily debrief will take off, and he'll fill in all the holes from anything you may have missed today on the merit case, on the Klaus matter, the testimony that we've been hearing more recently from California and from New Jersey. Again, Michael Bryant, happy to be here with you today. We'll see you next time on the Law and Crime Network.